I'm here to talk about the franchise agreement. Brian is absolutely right. You start by getting your business proposal sorted out first. Once you've got to the stage that you've devised your franchise offering and you've done your financials and you've started work on your operations manual, then that is the time to start talking to your lawyer about getting a franchise agreement done. So what I'm going to talk about here just very quickly is, why do you need a franchise agreement? What does it need to say? And some practical tips and some do's and don'ts. First question is, why is the franchise agreement so important? I know I hear it a lot and I understand the question. Does it really matter what it says, or aren't they all just basically saying the same thing? So can't I just take any old franchise agreement and just put my name on the top of it? Because once we've signed it, it'll just go in a drawer and nobody will ever look at it again, so it doesn't really matter. That, although it's understandable, is not right, because at the end of the day, your franchise agreement has to be handmade for your business. There is no such thing as a one-size-fits-all franchise agreement, just like there's no such thing as a one-size-fits-all business. Every single business is different, every single business model is different, and therefore every single franchise agreement needs to be different. Your franchise agreement does a number of key things. For one thing, it protects your brand. In the course of investing in putting a franchise concept together, you've spent potentially a serious amount of money getting yourself ready, and you will jeopardize potentially all of the value that you've invested in if you don't have strong and robust enough rights against your franchisees. So your franchise agreement has got to be tough, it's got to be robust, and it's got to protect your brand. So you need to be able to ensure that you can take the action that you need to take against franchisees if they are messing about with your brand, or if they are just doing things that are going to damage the reputation of your brand. As a franchisor, your brand reputation is everything. So, and if you get into trouble with franchisees, and inevitably, unfortunately, you will do, even the most successful franchisor businesses out there will have a certain percentage of franchisees that are poor performers, non-performers, and that have to be cut loose. And you need a robust agreement to enable you to do that for the sake of keeping your business secure and your brand secure. Another advantage of having a good franchise agreement is that it provides some certainty for you and your franchisees. It is really important for your franchisees to understand what they are letting themselves in for before they sign, and getting a proper franchise agreement done, and ideally getting your franchisees to get legal advice on their franchise agreement before they get going with the franchise is a very useful way of making sure that you minimize the chances of significant problems arising with your franchisees, because they understand in advance what is expected of them. So, getting your franchise agreement done, there is a cost associated with it, and there is time and effort involved in it, but it is worth it. In tailor-making your franchise agreement for you, we can make sure that it covers what your business needs it to cover. If we were going to try and put in a franchise agreement every single thing that could ever possibly go wrong with a franchise and catch all incidents, we'd end up with an agreement that was 400 pages long, and nobody would want to sign it. You have to hone it down to cover those things that are particularly important for your business. So one of the jobs for me as a franchise lawyer is to talk to the franchisor or my client and work out with them, what's the worst thing that can happen in your business? How can you practically prevent those things from going wrong with franchisees? And what do we say in the agreement about it? So just moving on to some specifics about what the franchise agreement is going to say. It's going to identify who the franchisee is. Now, that sounds a bit silly, because you would think, well, that's going to be obvious, isn't it? it isn't quite as obvious as you think. There are some steps you need to take to make sure that you are contracting with the right franchisee entity. Some franchisees will set up limited companies. Some of them will operate the business in their own name. Some of them as sole traders. Some of them may want to start off as sole traders and then move over to being a limited company later. It is very important that you capture that point in the franchise agreement at the beginning and make sure that you're contracting with the right entity. Your franchise agreement is also going to set out the term and the renewal rights. Bear in mind that your franchisees are going to be looking for an almost automatic right to renew their franchise agreement, and that's something very much that the BFA, the British Franchise Association, encourages, and they do that for a good reason, which is that they want franchisees to be able to realise a value out of their investment in the franchise. The idea is that franchisees should, all being well, be able to sell their franchise at some point during the term or towards the end of the term. So the renewal rights are a critical piece of that. You'll find also that a lot of your franchise agreement is given over to talking about marketing, who does what in relation to marketing the brand, how much local marketing does the franchisee have to do, how much national marketing do you have to do, and the operating requirements. A big chunk of it is going to be the operational do's and don'ts for the franchisee, and that is in particular what's got to be done tailor-made for your particular business, because everyone's is going to differ. The operating requirements are going to be linked very closely with your operations manual. So by the time you come to be getting your franchise agreement done, you should already have your ops manual done, or you should be along the way to getting it done. Because ideally you want the two things to be completed at the same time, because each is going to refer to the other. And also importantly, before I move on, your franchise agreement needs to set out the fee structure. You're going to have your initial fee, which Brian talked about earlier. You will want to provide for management service fees, which is going to be most likely a percentage of gross sales of the franchisee. You may want the franchisee to be putting money into a central advertising pot, which is often called an advertising levy. And there may also be other things that you want to say in your agreement in terms of charges. So software license fees, fees for the running of a CRM system, additional training fees. It's very important that your agreement covers all of those things. Your franchise agreement is also going to deal with some legal and regulatory compliance. In other words, who is it up to make sure that the franchise complies with the law? If the franchise is in a sector that's regulated by the Financial Services Authority, then you need to make sure it's clear who's got the responsibility for doing that. Another key important thing is your minimum performance criteria. You need to have some notion of minimum performance that your franchisees have got to achieve, because if they don't achieve it and you've granted them an exclusive territory, which you may well have done, there is a risk that they are just going to hog the territory and not enable you to exploit that territory the way it would be by somebody else. So the British Franchise Association would expect that there are some minimum performance criteria that you put in the agreement, which say if you fall below this level, then we will have to reserve the right ultimately either to change your territory or to terminate your agreement altogether, so that you can then put in another franchisee into that territory who's going to be able to exploit it properly. Minimum performance criteria, when I'm dealing with my franchisor clients, this is one thing that we spend quite a lot of time looking at, because what one business is going to want is going to be very different to what another business wants. As a guideline, the BFA will often suggest that you provide that as a minimum, your franchisees have got to achieve no less than 70% of the average of what other franchisees are achieving. So that is something that we often do put in, but there are other various ways that you can do it. Also, also, very importantly, your franchise agreement is going to list in very robust terms the grounds under which you can terminate the franchise. You have to have those robust termination rights in there for the sake of protecting your business as a whole. You will need to be able, as I said earlier, to make sure that your worst performers can, if the worst come to the worst, be cut loose. Some practical issues now, just to finish up. It is always sensible to present your franchise agreement to franchisees as being non-negotiable. That doesn't mean that you don't care about franchisees getting good legal advice on it. What it does mean is you don't want to get into the realms of negotiating franchise terms with each individual franchisee. For one thing, by the time you've got 20 or 30 franchisees, if you've done different terms for different people, you'll never be able to keep track of who's got what terms. For another thing, it's not fair on the franchisees, and they will get to know who's got one set of terms and who's got another, and that's a very typical bugbear of complaints of franchisees. And for another thing, you need to have consistency in your system. So it does make sense to say to everybody, in fairness, this is presented as non-negotiable, and to say to franchisees that they are very well advised to take the franchise agreement to a BFA affiliated law firm to get what's called a franchise agreement review and reports done on the franchise. Some people feel that that's a little bit counterintuitive, because you think, well, why would I want to encourage my franchisee to go off and get legal advice about the agreement that I'm giving them? Well, there are some very good reasons why it is a good idea, not least because you then ensure that the franchisee understands what he has signed up to, and you won't have him coming back later saying, oh, well, I know that's what you're saying now, but I never realised. So it helps you enormously on the enforcement of your agreements and in trying to make sure that you get proper franchisee compliance if you make them or encourage them to go and get a franchise agreement review done before they sign up. And when they do go off to get a franchise agreement review done, do encourage them to go to a BFA affiliated lawyer, because the BFA affiliated lawyer will understand what franchise agreements are likely to look like, and they will have realistic as opposed to unrealistic expectations. What to do when things go wrong? Most important thing is to anticipate that inevitably things will go wrong. Contractually, things are bound to go wrong, and you shouldn't take it personally when one out of your first 10 franchisees, let's say, gets into legal difficulties with you. It is unfortunately part of the nature of franchising, and you need to be prepared for it. So always have in your mind that you are going to have to budget for some degree of legal support along the way in order to make sure that you can act promptly when you have problems that arise.